Hey all, here is a replay version of the most recent live stream Q&A on all things Social Security that occurs every Wednesday at 1 p.m. Eastern Standard Time. So this is with all the little silences carved out of it. So I hope it's an easier listen for those who are doing the replay versus being there live. And we'd love to see you live. So feel free to pop in. Bye-bye now. Hey guys, thought I'd pop in a couple of minutes early since I'm here. Let me find my comments so I can see you. Hey Mike Page, good to see you. Just let me know you guys can hear me. I think you can. I think we're kind of slowly past that, knock on wood. What do you think? Yes, I can hear you. Thank you, Earth One. Do I butcher that every time? Okay. All right, so I don't know how you guys did this week. I hope we have some good news as someone who got some positive results. I had a hearing yesterday. It was not bad. It's not going to be closed, though. It's not a matter of not winning. This is what happens sometimes, guys, when you're over 55. We've talked about this, right, with the grids. And your alleged onset date was when you're in the 50 to 54 range. And now you're going to a hearing, and he's got to look at, well, was the person disabled under the rules that apply at 50 to 54? Or if not, if I can't find that, I can hit her down to sedentary under those pieces of evidence, and I can only get her at light or something. Then the question is, all right, now that she's over 55, then they can, if they find that it has been light at any time since, at least once she hits 55, the light rule applies. And if she meets all the other things in a grid, all the other requirements, such as past relevant work and all that, she can prevail as a 55. And this has been going on for a number of years. Not that the rule has changed, but it seems like, I don't know, 3, 4, I don't know, something a few years back. And I've talked about this before, it seemed like suddenly we were not getting our 50 to 54 prevails. We were only getting them at 55, which for some people means no back benefits. Of course, for us, that means no fee, but that's the risk we take. It's more important that a person rightfully, in my opinion, get prevailed on an earlier age, if they were in fact disabled on an earlier age, if they have the evidence, of course. That's why always nagging about getting that evidence, and not everyone follows it because it's inconvenient and they're tired, and sometimes there's depression and things like that. But getting the evidence when you're told you should, get that follow-up, even if there's no treatment that's going to cure you, just keep going, as if following up with your many specialists is your full-time job, even though it's not full-time. That's what can change that. So I just want to drive it home that you want to, ideally when you think you're going to apply, even if you haven't applied yet, but then thereafter, you want to really go to town, make it like it matters, because otherwise you could lose out on years of back benefits, even if you still prevail. All right, so that was my big shindig. I will say another thing about the hearing. The DDS on initial and or recon had placed the person, and I came in kind of late in the day, like when it was already like either on the way to hearing or we had to appeal it or something. It was all crazy. And I think they took some time getting us on board and stuff like that. But the lower levels had denied the person as being they could do medium level work, and which is, you have to be able to lift up to 50 pounds. It's between 20 and 50 pounds for medium, and it's definitely out of the question. I do feel the judge in the argument, I do briefs, and my brief gave the argument of it should be back to her alleged onset date. And then there was 2 alternatives, even though I said, or any time thereafter, if you find the sedentary evidence is found after onset, but before 55. And then, of course, at 55, you can expand that to sedentary or light. I got the impression that, we're looking pretty confident at least at 55. But really what we're, hoping to do is always bring it back as far as possible. The idea, so I should say the VE question started out at the medium RFC. And I'm like, what? And I think that's only for thoroughness. I believe he did that for thoroughness, since he has to kind of go against he has to find against the DDS no matter what. So he could still find medium RFC, but find that she couldn't do her prior work due to, say, cognitive concentration issues, due to pain and other things. So the prior relevant work would be, point A made, age is made, wouldn't be able to prove the person is limited to sedentary light unless the judge finds inconsistently with the DDS. DDS was ridiculous. You almost feel like they gave it to her deliberately so that even at 55, you're going to be screwed. There were questions added by both me and the judge. And one of them that he did, and I expounded on it a little bit with the VE, but he did bring in if the person was going to miss 1 or 2 days a month for medical reasons. And the VE confirmed that there would be no job, zero zip, of an unskilled job, which the mental health was very robust all the way through, that it would be down to unskilled. I know a lot of people think I can't work because of my mental health, and they think they're going to prevail on a mental claim only and not put in their physical problems. And that is the biggest mistake somebody could make. Probably second, maybe not second to none, but it's really huge because unless you're institutionalized, and I'm saying this generally, guys, of course there are exceptions, and we have cases where it's been non-institutionalized but severe agoraphobia, OCD. There's a lot of proofs that you have to do, and the person has to be really, really treating and all sorts of special things going on in their life. Very symptomatic schizophrenia with psychotic features, not necessarily without psychotic features, and there might not be hospitalization. But for everybody else with the anxiety and depression, the chance of them finding you can't do unskilled, simple third grade work without having to be near the public or coworkers is very, very slim. Even if you know you can't because you can't get your butt out of the house because of the depression, that stuff is very hard to get strong enough objective evidence of a medical nature. We had the unskilled in the bag. I was never going to be writing the case on mental, even though that's how it came to me. And I'm like, no, this isn't going to fly. So the whole major thing was proving that you can do the grids. You can also, in the more difficult way, do it without the grids or without being fully mental. If they can't win a grid, they can still prove through cutting out all the jobs individually, 12,000 and something, that they can't do them due to, it could be that finger arthritis. It could be that the neuropathy in the feet. Carve out some, like everything gets carved out from different things. Pardon me, I don't know if I have a little allergy or something. I didn't take my allergy medicine last night before I went to bed. And I was in bed and I'm like, oh shoot. And I didn't want to go downstairs and get it. So I didn't. And then I should have taken it today. And then I forgot because I don't take any medicines in the morning or anything. Anyway, so that was interesting. But I got the distinct impression and kind of said stuff on the record that alluded to 55 and above. You got that in the bag. Let's keep the hearing open. There was some straggling medical evidence to get that last bit in, see if anything is retro to the 55th birthday, which was just last summer, and possibly a consultative exam. And I did ask about that. I said, well, if we're trying to prove, Judge, that it was before July of 2025, what will a consultative exam do now? And he said, yeah, I hear what you're saying. He goes, I go, unless you give him exact questions that you want the consultative examiner to say, like, do you believe she was in this condition? And he gave a good caution, I thought, to the client, and he was very kind. He said, if I do, schedule you for a post-hearing consultative examination. If I do schedule you for that, I would just caution you to do your best. And what he meant by that was be honest, be frank. Don't be a malingerer or an exaggerator, but don't do the, not telling the person, everything they need to know. Because he said the last thing we want, he goes, I'm doing the consultative exam potentially to help your case. I don't want to see you do something that then risks your whole finding that he's obviously feeling right now. So you don't want a negative result out of the consultative exam. So I did kind of question the consultative exam just because of the fact that it's past the point where this consultative exam, I said, isn't that just a snapshot, Judge? And he kind of agreed. He's like, yeah, that is a snapshot. And he goes, maybe a medical expert. All of these things involve risk. The medical expert, when they do that, is all in the papers. He doesn't examine. And he will look at the entire medical file, and the judge will give to him a series of questions. First, to see if anything's listing, and then, if not, what is the RFC and all that business. So that might be something, the risk of anything going the other way where, she's not even at, like, we think she can, like, the whole flip around of that is unlikely. But until you have your win in your hand, there's no resting over here. So we got a few weeks to figure this out. All right, that was my day yesterday. I hope there were some tidbits for you guys in there about hearings anyway and how they might go. There was a plethora of hypotheticals. Well, I actually added a few myself, but I don't know. I thought it was good. All right. Let's go to, we see Kevin Johnson is in the house. Funky Form is in the house. I don't think we've met Funky. George Graham, always good to see you. Mike Page, as always, my friend. Stacy's in the house. I don't know if I know Stacy, but she says, I'm so glad I found your channel. Michelle's in the house. Good to see you. one. Let me just see if there's anybody else. John TB. Let's see. All right. I'm going to go back up because Kevin was first one. Thanks for tolerating me, Kevin. Kevin had his hearing. It lasted less than 10 minutes, Kevin's telling us. He said there was no questions posed to the VE by the judge, and the judge gridded me out with an onset in July of 2023. That's amazing. I got both SSDI and SSI. What does that mean? Okay. If that means you applied for SSDI and you applied for SSI. So both claims were pending before the judge at this hearing. All right. You had to apply for both. And the SSI one is not automatic just because you did SSD. In theory, if you do SSI, it is also an SSD claim until they find out that you're not insured or whatever. So the judge heard them both and he found you disabled as of July 2020. You had an SSI application in that time at that time and going forward, and you had an SSD. Well, your SSDI application likely came much later, but that's fine because you can go retroactive. You can go retroactive forever. They just won't pay you. Like, let's say you found you were disabled 10 years ago. That's great. You're not going to get paid except for a year before you applied, not all the way 10 years back, but he'll still make the legitimate finding. SSI, they don't tend to do that. For whatever reason, because there's no retro, the rule, well, it's probably not because there's no retro, but the rule is they do not make a finding of whether you were disabled before the date you applied. So if you apply for SSI today, they're never going to look to see if you were disabled before that. They will look at those records to see if they led up to. But the finding of disabled will always be no sooner than the date you applied for the SSI. It's a real pain, that rule. It's funny how it interferes with things in other ways that I wish it wasn't the case. I wish they would make the finding all the way back, but then only pay you from the date you applied. That's fine. But the finding could be really useful in other areas. Legally disabled as of 4 years ago versus 6 months ago. All right. Kevin continues to say, is that the found money you're referring to? Yeah, I refer to found money all the time. I do this when it comes to applying for SSD. A lot of the time, I've seen representatives do this. I've seen big law firms do this that I've given some consulting work to. And I'm like, no, you don't want to do that. If a person is insured for SSD because they've been a solid worker recently enough, but they're poor and could feasibly be poor enough for SSI, bang up both applications. They should be filing for both. The reason why some maybe case managers at law firms are saying, no, because the SSD is going to be more than what SSI would be and it's going to negate it. Well, that's true for the months they get both. But what about those 5 months when you can't get SSD? Even though you've proven you're disabled during those 5 months, you can get the SSI because SSI does not have the 5-month waiting period that SSD has. So when you apply the same day for both, or in the same vicinity, and you prove that in fact you were disabled maybe back here a year before you applied, the SSD can go back. The SSI will only go from here forward. Now, in that case, you're not going to get the SSI if they found you disabled way back when, because your SSD would have been paid. The first 5 months were not paid, but then you were paid from the next month all the way to the present through the SSI months, and the SSI is not eligible for it for those months. However, a lot of times they don't agree with not only your old date, they may not even agree with the date you applied or shortly thereafter. They can make their own established onset date. So if they decide that you applied on this date, we don't think that you were even disabled until 6 months later, you had an SSI application in back here along with the SSD, but you weren't disabled till here. And so here is where the SSI starts to get paid, and you have 5 months of no SSD. So that SSI is being paid. And that could be, what are we, almost $1,000 a month for SSI? That could be $5,000. That could be paying most of your attorney fee. So, why not put in the application? There's no additional medical workup. Everything smoothly works together. You just have to do the SSI application, which is just about what money do you have in the bank and da-da-da-da. And they will usually want to speak to you on the phone at the time you apply. And they generally do not want to speak to your attorney about that. They want to make sure the finances are before I would think this would almost be more, they might do this more strictly when someone doesn't have an SSD claim. Because why go through the trouble of the whole medical workup for a year or two and spend that money for, if the person would never be eligible for SSI anyway because they got 10 grand in the bank and they refuse to use it on something, spend it properly on great things that they can, use going forward, but to bring down that countable resource to under the 2,000 if you're single, 3,000 if you're married. And of course, that's been the same number forever and it's not right. But yeah, that could be. It depends, Kevin, where your numbers, your dates are going to fall when you applied. Like if you applied at the same time and you're not getting SSDI for July, August, September, October, November, you can get the SSI for that. If when they go back retrospectively and look at those numbers with you, because they're going to want an interview after you went to for the perk interview, if you show that you didn't have any income, countable income, whether it's in kind or cash, and that your resources didn't exceed that $2,000 limit. And we're not going to go into resources right now, but as you know, you can own the home you live in. That's not counted for SSI. You can also own one car. But if you have two cars in your name, you could have a problem. So I have people who do that and they continue to do that and they can't get SSI and they refuse to give up a second car. So I don't really get it, but that's the way it is. I do sometimes get it. Like someone keeps it in their name because their child needs it and the insurance would completely wipe out the cost if it was changed in names, all that ridiculous stuff. And I know about young adults and car insurance. I got two of them. And my car insurance exceeds my mortgage. Suffice it to say. Teenagers, what do you want? Yeah, I can't wait till that's over. So yeah, that could be fun money for you, Kevin. It may or may not, but why not? Didn't cost you any extra effort and very little extra effort on the part of your representative. Okay. Okay. Funky Form. I don't think we've met before, Funk, but thanks for visiting. I appreciate it. It's Funky Farm. I love farms. I got to tell you, I'd like to live on a farm. I used to live on kind of a farm growing up, and I'd go back to New York. I mean, I did not appreciate any of my childhood at the time. I definitely took it for granted, and I wanted to live in like a tight-knit development because all my friends did. Yeah, that was really stupid. All right. I was reading this before, Funk. My LNL, I don't know what that is. Can you post up what LNL is? It says, my LNL is possibly closing. At first, I thought maybe you meant your DLI, but that would be a severe typo, and then you typed it in again, so I don't think it's what you meant. My LNL is possibly closing and also have Hartford Insurance LTD. Okay, the LTD, I got you there. As well as applied for SSD 2 weeks ago. Okay, great. Question is, does Hartford continue to pay time loss when I don't know what LNL is, so I can't answer this question. LNL, I don't know what that is. Sorry, I'm not an LTD attorney. But I will say that while you wait for SSD, if you are collecting LTD and you are still eligible for LTD and you meet all their obligations, they do continue to pay you. They will probably, if you win SSD for the same months that you in the past collected the LTD, they probably have something in their contract with you that they can offset that what they paid you is retrospectively too much, and you should return basically the amount that you got eventually covered by SSD for that month. That's usually how that works these days. It didn't used to. You can actually buy a policy that doesn't do that, but it costs more. And if it's an employer policy, they're probably going for the cheapest one because they're providing you with something that's of great value and at great discount to you while you're working, the LTD. Okay. I will probably come back to this when you give me that LNL. I don't really know what that means. LNL. You guys know. Maybe I'll scroll down and see if it's in there. Oh, labored industries. You mean workers' comp? Remember, there's 50 states and they all call it something different. But I think you mean workers' comp. But let me know if you mean workers' comp. I'm going to assume you mean workers' comp because that could kind of fit into the scenario, maybe. A lot of times people have LTD, workers' comp, SSD. So, question is, I'm going to assume it's workers' comp when you said labor and industries. Does Hartford continue to pay the time loss? I mean, they're not really paying you the time loss. They're paying you the benefit that they promised as long as you're disabled from working. So that's kind of like a workers' comp. So workers' comp is ending. That gets a little convoluted because I can't really speak to the LTD. I don't think the LTD, well, I shouldn't say this. I can't really speak to the LTD and the workers' comp. I don't do LTD. SSD and workers' comp, it's going to be about whether any of those months that you collect retrospectively or prospectively, if you settle and it's stretched out over the course of your lifetime till you're retired or whatever, or your life expectancy, you settle your workers' comp. SSA and workers' comp are going to want to know what your ACE is, your average current earnings, which is not actually current. It's what you were making before you became disabled and unable to work. You looked at the last few years, it gets some sort of average monthly amount that you were earning before you took a dive. And there's the 80% rule. So if you're getting both of those benefits, SSD and workers' comp, on any particular month, and you have to figure out which months you're getting it for and all that, and that amount goes over 80% of your ACE, there will be an offset. And so the amount that's over 80% of your ACE that you're getting between those two is going to be offset. Other workers' comp is going to call it back, or SSD, because the law says you can't make being disabled with two governmentally involved, I'm going to just use that word, insurance programs for disability, you can't collect more than 80% of your ACE, because otherwise, I think the theory is it's kind of really too profitable, and it would maybe encourage people to become legally disabled. And when I say become, do I think people are going to throw themselves in front of a car? I don't, but there is too much incentive for fraud anyway, so it prevents that aspect from being something that would bring up the fraudster in anybody. So, it's not supposed to be a windfall. I don't know why Tasha's here, but she's being antisocial. She just had some stuffed mushrooms with me. She hasn't been in here in a couple days. It's been like a whirlwind, and I just didn't have time to worry about her. George Graham's in the house. Says, great afternoon, Stephanie from Punta Gorda, Florida. Nice and warm down by you there, George, not up here. Good to see you. Mike Page, he had said good afternoon. So we got Stacy6682 says, so glad I found your channel. So glad you're here, Stacy. If you have a question, don't hesitate. Michelle congratulates Kevin. That's awesome. And thank you, Earth One, for letting me know you could hear me and that the microphone was working. And Michelle as well. Stacy's got a question. All right, Stacy, does a public assistance house have less paperwork? I wouldn't know. I don't do public assistance law, or qualify for full benefit amount? I don't know. I really can't tell you. I'm very sorry. Public assistance houses, you often pay whatever they tell you to pay, whether it's a third of your income or whatever. So I don't think, just going on a whim here, you'd have to really do your own due diligence with public assistance housing, but I don't think they would detract from your SSI. I don't think, but that doesn't mean I'm right. You're welcome, Kevin. John TV says, can friends or relatives vouch for you? Vouch for you for what? Can you be more detailed, more specific? I mean, vouch for you to say you're a citizen so you can vote? I mean, we have that whole thing going on, right? Apparently, in some places you could do that. Mike Pace says, you're absolutely correct, Stephanie. That's how I won my case. What mental health and arthritis and neuropathy and plantar fasciitis. Yeah, yes. Mike got over the line. That was great. Yeah. FB says, hello, Joy. Well, hello to you too. VB, I'm sorry. Kimberly Rainey. Hi, Kimberly Rainey. I'm at Recon since October 2025, and the now reason is condition results in some limitations, but condition not severe enough to keep me from working. Okay. Well, that's true of people that are actually working too. They have impairments sometimes, and it's just not enough to keep them from working. They did not have my medical records from doctor office. Well, I assume you're self-representing, and your job is to get it to them. So you have to be on that. If they make the request, and they're supposed to make it twice, I believe, of a doctor who doesn't send, then they will move on. Now, because, they can't leave your case open forever. Now, sometimes, often, but maybe not always, I've seen ones that they don't, and then it's kind of screwy. They give up and they don't alert you, whereas you could have just contacted your doctor if you knew. Sometimes they do reach out after their first failed attempt. When they send their second request, they also contact us and let us know that, contact the doctor, client, the patient, contact their doctor and ask them to pursue. And that is sometimes a really good trigger, because we're not supposed to send in duplicates. So we're not all ordering records at the same time, generally speaking. But when they do that, now that there is a problem, we will sometimes send out our clients pre-prepared high-tech HIPAA requests and they're basically asking their doctors to send them the records at the fax or email they put down there. That way, if we get them faster, you can sometimes a doctor will, I guess, pay more attention to their patient, which is kind of nice actually. But I wish they would realize that the SSA is actually working to help the patient get the records. We're not supposed to send, the reason why we don't initially order the records is because you're not supposed to send in duplicate records. It's very frowned upon. In fact, at ALJ, you'll probably get a severe spanking. So you have to, and you're not in the file every day, obviously, or else you'd never get any work done on all your cases. So you go in there periodically and you see that they're having a problem getting something, that's sometimes a trigger too. I see that they sent a copy of a request out a month ago and there's been no response, and I could see that. Then I'll be like, let's pop out, the client's, layman's high-tech HIPAA that they've given us. Let's facilitate that to their doctors and get it that way. And try to get it that way. Recently, speaking of getting medical records, there's always problems, right? But not through every provider. So it all depends. A lot of misguided office managers or records people in the doctor's offices are not highly informed about the law that surrounds their job, which is very bizarre to me. But some are. And then you have the ones that aren't. They fail to realize they have a 30-day time limit. So we actually sent them the article on it with all the HIPAA rules, as well as a couple articles about some doctor's offices that got nice financial fines when people were just complaining enough. That would be the Office of Civil Rights doing that. And they won't do it just because we send in a complaint. I believe, I mean, there's not a lot of bite, unfortunately, to the HIPAA law, except maybe the privacy portion of it, which I think is really terrible. I think they should do a little more biting. Maybe to give the person a little warning first, but and give them a really short window to respond since they blew off the 30 days or the 40 days or however long they've blown it off. But I do wish OCR would take the access provisions of the HIPAA law, access to the records, and the high-tech version in particular more seriously. And that's what it was designed to do. But the providers don't get slapped, so they continue to do it. And they continue to remain ignorant or keep their staffers ignorant, I guess, because it doesn't cost them anything not to. So why put more burdens on them where they have to act faster? Within a whole month, they have to get out your medical records to you. And that definitely concerns the high-tech HIPAA, which is the ones where you're asking for it to be emailed or faxed to you. They don't have to print anything. They don't have to stick it in an envelope. They don't have to pay for ink, paper, envelope, stamps, and manual labor. Rather, the only thing that they can charge for, they can't even charge for a search fee, the amount of time the record sender person clicks the buttons, because everything's electronic, right? And shoots it off to the fax number, which is also generally electronic, or to your email. So I would gather that 15 minutes would be on the outside of the time needed. So when they try to charge you like $300 for that, I never met a records person, office helper, who made $300 every 15 minutes. So I don't think that's really legitimate. So we did have to smack someone down this week about that and send them the roll on what you can charge, because they were charging my person, they wanted $25 just for the pleasure of getting off their butt, and then $1 a page. And this was in a southern state. So we sent them, and they're probably going to be, I mean, it's not really from us, it's from the client, but it's like this, repeated article. I just tack it on the back and resend the request and say, so they know, like, listen, if you think that your rules supersede the federal government's HIPAA rule, I think you got to learn a little bit some. So we just try to help them in that regard. I consider it a public service announcement for them. So Kimberly, that being said, you need to go get those records and get them in. You're on recon, and if you haven't gotten what your denial letter said was missing, that would be a mistake. You can call your adjudicator and find out if they've gotten them since. If so, from what date to what date. Find out everything they've gotten, take notes, and then know what they don't have. And then you got to really move it. I mean, you're choosing to be your own representative, so you have to do this for yourself, because there's really no one else to do it for you. Kim goes on, because they keep saying they did not receive the fax request form. I have left that doctor's office and going to see another one. What advice do you think I should do at this point? You know what? You fax it to them with them on the phone and be like, did you get that? And also, did you confirm the fax number? Get a fresh fax from them. You send out perhaps your own high-tech HIPAA. If you do, and they send it to you, they can't really charge you more than $10 for those records. Okay? So that is something I would do. You do want the old ones, for sure. And obviously, you want to make sure the new ones. So, if you are self-representing, you have to make the phone calls with your adjudicator. You don't have a lawyer to do it who sends letters or calls or whatever we do at various times. So you kind of have to just buck up and do it. I'm not saying you wouldn't. I'm just saying I don't think you did, because this is, you're asking about it now when you're in recon. Good afternoon, Randy Gore. Randy Gore? Nice to meet you. We always watching. Says, it is getting hard. It is harder getting back on disability after being on disability most of my childhood years for RA. I'm 30 now, and mom died, so I'm applying again for SSI and DAC. Well, it might be because you might have a technical difficulty. Why did you get off of it? What happened? That were you found not disabled at 18 after being on it from a child because you didn't meet the adult standard? If that's true, you probably can't go and relitigate that, most likely. Or did you, but then you got a job that was SGA, even though it wasn't for very long, and now you're getting worse again? Then you interrupted the DAC. Yes, you can apply for SSI. And if you work part-time, even with the RA, something very genteel, you could gain back your earnings credits so that there's some recent ones earned and become yourself insured for SSD on your own work record. Doesn't take much. I'm going to throw out a number out there, and it's less than this, but this is a safe number, $9,000 a year, a couple $100 a month, maybe. Is really a week. I mean, I don't want to throw out the exact number. It really varies between self-employed and W-2ers. So Gets confusing. VB says, what to expect at a remand? All right, so it sounds like you got remanded, what, by appeals council or by federal district court back to most likely the same judge for giving him an opportunity to correct the mistakes he failed to do correctly at the first hearing and first decision, so he can fill in those gaps. So it's going to be exactly the same by and large. What you need to be doing, I assume you have a lawyer that's doing this, but if not, you need to be getting all the really robust treatment and follow-up you've been doing since your last hearing and the decision, the one that you got denied on. You need to submit all that stuff. You're at OHO again, Office of Hearings Operations, which I think they just changed the name, and you're heading to hearings. So you need to have all those updated records. So that actually gives you a better chance of winning because now you have new records to help convince that old judge that, yeah, see, I got this too, and, but you need this. So the hearing is going to be the same by and large, with a VE if you had one, most likely. And you got a second bite of the apple. So don't waste it. Get moving. So FB decided to or wants to file a complaint for discrimination. Now you're talking about a complete thing that's outside of the realm of SSD, so I'm not going to address it. Can it be done even if decision is favorable? Anyone can go claim they were discriminated against illegally. So if you were, you're going to a different judge. You have to go to a discrimination lawyer, right? If you're saying he discriminated me because I don't know why, I don't really have proof, but he denied me, so I must have been discriminated against. It's probably not going to fly. So hopefully you have some real concrete evidence. Like he said, you're a nasty female and I discriminate against females and this is why I'm denying you. You better have some goods because it's most likely not going to be on the record like that. But you'd want to talk to a discrimination lawyer. Listing 12 details helpful. That doesn't tell me anything. It's mental health though, I presume, right? Dimple's in the house. Hi, Dimple from Ohio. VB. I keep saying FB. Facebook. No. VB says support physician retired. Are you saying you had a physician who was really supportive and he's no longer treating you? I know, and they retired. The good ones retire. It's really troublesome because a lot of the replacements now of a different generation are just not as good. And it's not that they are not as good. I feel like their hands are more tied by big medicine, big insurance. They're all in these networks. They might be a little better. Not sure if they're mom and pops. What do you guys, if you guys have opinions on that, feel free to share. It's a pretty big topic around these parts. Definitely not happy with regular care for regular common people's impairments. I just think it's not great. Kevin's saying that when he filed the SSD and the SSI together. And so then it depends on what your date of application was, what you're alleged and all that, to see if you'd be getting some of that SSI money during those 0 months of SSD. Sunflower's in the house. Hi, Sunflower. Is there anything negative that can result from attending a virtual support group for my health condition? I don't think so. I can only do a virtual, not in person. Can they use this against you in any way? First of all, I'm not sure they're going to know because I think those groups are usually closed, right? Secondly, in what way would joining a virtual support group act as any kind of evidence against your disabilities? Now, if you were saying absolutely cannot use electronics and you're using them like you are here, but I don't think you said that. So I don't see why that would be bad at all. I don't see how it would be bad at all. Mush love. Hi, I'm new. Nice to meet you, Mush. I have a question. If you are working and making less before your hearing, will that affect your case? Well, if you're working, he's got to consider what you're doing. Pardon me, guys. I got to between a nose itch and whatever. If you're working and making less before your hearing, will that affect your case? I mean, were you working when you applied? You're obviously denied twice. I don't know what basis you were denied on and what your impairments are. It is entirely okay if you are otherwise disabled from full-time work and you're not earning SGA to be working and earning SGA. Now, the other side of the coin is, what kind of work is she doing? Is it contrary to what she says she can't do that amount of? So what you say in your function report, really goes a long way to what you would be doing at work. So if you are doing something at work that is different than what you said that you couldn't do in your function report, that could raise some eyebrows. So just be careful. I have plenty of people who are penning the claim, plenty. And we always make sure that they're not doing something that on paper would look like something is inconsistent. It could even be they're doing something and they're trying their hardest to do it and it's not going to last 6 months. Then it could be a failed work attempt. However, you do not want to be doing that at the time you're hearing if you're over SGA, which is what is you have to be over SGA to be held accountable for that work and then to use the unsuccessful work attempt argument. So if the person is over SGA and they go longer than 6 months, they are most likely going to have to lose their case because they just proved that they had a sustained period when they could work substantially over 6 months, 6 months or more. So always, always, always know your numbers and stay clear of them. Don't even flirt with them, guys. Kevin says, no cars or money, stayed poor the whole duration. Well, I'm sorry about that, but maybe now you can get a car. Assuming you drive. If you don't drive, no big deal. Now, the good thing is, Kevin, and this is a reminder, but he has SSD. I'm going to assume for the moment, Kevin, that your SSD exceeds the SSI, and therefore you would get SSI. Exceeds it by at least $20. That's not always the case, though. Then you'd be dual, and you keep getting SSI forever to tap it up a little bit. That's kind of a nightmare. But it is more money. If your SSD is going to kick out your SSI, what the beauty is, when you get your SSI back check, you don't have to spend it down because you're spending it down. When you spend down, it is to keep you eligible for next month's SSI payment. You're not claiming for next month's SSI payment because you have SSD and you know you would be eligible for SSI because your SSD is greater and more favorable. So that is one nice thing. Like the SSI, if you're getting some, you don't have to like be like a person that's only on SSI and counting on it prospectively, where they have to keep an eye on. They give them a certain amount of extra months to spend back benefits so they can make wise choices. Whether they do or not is another story. I always have my opinion on what you should be spending it on and what you shouldn't be. If you want a better financial future anyway. But yeah, it could be it's a nice fact when you get that. That's different from other SSI recipients because yours is a past thing and it's over. Okay, Funk said yes. I think you're saying yes, it was workers' comp, right? I hope I answered your question. Hey, we've got 7X. You look familiar. I'm assuming that's not a picture off the public shared pics. So I probably know you, right? From here. So 7X says, coming up on 6 months recon. I just asked my attorney, when should we turn the new evidence of it? Had a third back surgery and a fourth one in the process of being approved. Well, what did he say? To me, my adjudicator probably would have known about it before the surgery even happened. Say, hey, this is pending. And the reason why we do that a lot of the time for big things is because, gosh forbid, they make a decision prematurely, in our opinion. It's like, wait a minute, you didn't have everything, and that happens. That just happened on something. It was horrible. I think they had it for 3 weeks, and my person just got denied. And I'm like, asked for the medical records like 10 days ago. You didn't even give them doctor time to get it. Ridiculous. So obviously we're appealing, but very frustrating. Yeah. I'm curious what your attorney says. Every attorney is different, and I'm not going to speak to why that might be. I say you get that in. I will tell you, and this is kind of, we have this portal, right? And my clients have something we make. It's got a message center in there, and so you can make a message with its title, and then everything about that message title, ongoing conversations about that issue, ideally, is in that thread. You want to talk about something, you also start a different one. We have one that everyone is supposed to have that we start a thread. It's got plugged in directions in the first message. And the thread is called medical visits updates or something like that. Continuing thread. And ideally, and some people forget to look for and just do message us when they have a visit. We want to know about every visit in real time. Not when you're at the doctor's office, but when you get home, some people will be like, no, I do it on Sundays. That's fine too. Other people just totally forget. And it's to the detriment of their case, actually. So the people that are anal about getting in there and doing it, everything they do in there triggers us to do something separate from what we would otherwise be doing. So when someone puts in 2 weeks worth of visits, we don't do it every day, obviously, or all those to the adjudicator. And we'll do it at least once a month. If it's something big, like had the surgery or had to go to the ER and get admitted the last 5 days, like I'm getting that to the adjudicator the day I see it because I want them to have, they're supposed to order the records. Sometimes we'll send them a portal version for, our clients that have patient portals. They don't really prefer the portal version because it is not the full set, but it's better than nothing is the way I look at it. So while we want to respect their desire for the official set, in the meantime, I need them to know about this. So we tell them about it, or sometimes let's say it's an MRI result. I want to pop that up because if it's mild or negative, I'm not going to. But if it's because they're going to get that anyway. But if it's something imperative that could change their perspective, I'm going to pop it up. So the more people give us the information in this very convenient portal system we have, the more action goes on their case. So, and it makes a huge difference. It absolutely makes a huge difference. It might be why we have so many recon awards. It just might be. So, okay. Hope that answered the question about what I would do. I don't know what your attorney practices. WC says, would you be found disabled at ALJ hearing on grid rules if you were 54 and 10 months? I know he's talking about age category change, and had been denied saying you could possibly do light work. No. Well, who denied you? The underdogs, right? And they're not really underdogs. That was a bad choice of words. The underlings, the underlevels. So let's go back to the question. Would you be found disabled at ALJ hearing on the grids if you were 54 and 10 months old and had been denied? So if you're 54 and 10 months old, if you can do light work, you can't win on a grid. If they find you can do light work, obviously you don't think you can, or else you'd probably be out there working, right? Yeah, well, you can't win on a grid. In theory, you could win on something else. Like, despite the fact that I can do light work, none of those jobs that are light are doable because this one requires fine finger dexterity, and I have severe arthritis in my fingers. This other one requires acute hearing and a lot of phone work, and I have horrible tinnitus, and I have hearing aids that don't fully work or whatever. You can win on RFC without hitting a grid. It's just much harder. It's much harder because there are a lot of jobs out there, and you have to really nitpick and carve out all of them because you don't get to carve out. No, you don't get to carve out the ones. How do I explain it? That the grid kind of carves out by virtue of meeting the 3 prongs of the grid. And we have playlists on the grids, guys. If you're not sure about all that stuff, I love the grids. Grids. All right. So I hope that answered the question, WC. So yeah, if you're found to do light, he can't award you under the age of 55 unless somehow an age change category would come into it. There is a video on that when you change age category because it puts you in a different grid rule. And that grid rule at 55 would be even if you could do light work. If you can't do your prior job and those skills from your prior job, if any, cannot be transferred to something in that light range other than the job you had, you could win at 55. Fingers crossed for you. If it slides sideways and you need to review it, definitely feel free to reach out to me. Definitely tell me if you do, and hopefully you're just going to prevail, and this is going to be a nothing burger. But if you do, and this is only if you don't have a lawyer, obviously, or you're not going to represent you if it goes sideways, mention your name, your screen name, and the day that we spoke, and someone will confirm it and send it right to me, and it won't have to go through the regular thing. We've got Polak. All right, let me try to get this. Oh, is that Polak Elliott? We met before. Polak. I know we probably talked about this too, because I'm always trying to write the names, I do remember you. You were in here a couple weeks ago. I think the part that I remember the most is the Elliot at the end. That was on my boys' list for when I was having a baby, and I knew it was a boy, my second kid. It's on my top 10. And my husband ultimately made the decision because I was just like, as long as it's one of these, I'm good. It ended up being Jacob. But Stacy says, no SSI has a clause that if, Stacy says no, comma. I think that's what you're saying, right? SSI has a clause that if one or more occupants gets PA, public assistance, it is deemed a PA. Yeah, there's all sorts of stuff. I don't get into it because that housing is all varies by states. There's 50 states. I'm not adding 50 new areas of law to my plate. So I kind of steer clear of that. We try to stick with the part that we're hired for, which is not that it's not worth researching a little bit, time permitting. And sometimes I do that. And then I was doing it when they were changing some of the rules, just to kind of put it out there. But I don't really practice them. So she's saying that, yeah, it's deemed a public assistance house, ? My 5-year-old gets SSI on her payee. Yeah, I historically got approved medically for SSI, waiting for PER, lived together with my mom and daughter, no way to pay, so going to do a bona fide loan on shelter. Any tips? I can't really give you a tip on what to do based on that information, other than if the bona fide loan paperwork, and they have forms for that you can use, you've probably found it. That's good. And if they ignore that, then it's, there's 2. You can even have the mom sign, you sign. I would fight that. If you were on the hook for rent and your mom's cutting you a break by letting you slide until you get back on your feet, and then you got to start pay the rent, and plus throw an extra $25 a month to make up for all the couple years or whatever, I would appeal that. That's not a medical appeal. So it shouldn't trigger any kind of medical anything. They're not able to review the decision that they already made on the medical. It would be purely non-medical because I believe, and I meant to look this up the other day because I saw this problem. I'm not someone was telling me, but I believe it might be in POMS somewhere, POMS, that they are supposed to, if paperwork is submitted and there's nothing to the contrary to indicate it's false paperwork, or she's really not on the hook. And those bona fides can be after the fact saying, I've been loaning her this on a verbal for 2 years. This was our understanding from 2 years ago. They're supposed to accept that, your word on that paperwork signed under oath, so you could go to prison if you were lying about it existing as an arrangement. And that is supposed to be what they do, collect the confirming documentation. Both parties swear to it, and there's nothing to suggest otherwise. So to me, I would appeal. I will try. I'm going to put a note. I'm going to try to get that because that's kind of a big deal. And think it's happening a lot. They don't think you're going to appeal, perhaps. So they just say, no, you get a third rejection. Let me just say POMS, evidence, consideration, I guess, of bona fide loan. God, my handwriting is horrible. All right. I will try, Stacy, to find that POMS because remember, it has to be the arrangement was made back when it was made, even if it was verbal. Yeah, of course I have to pay my mom like she's not loaded, and if it is, it is, fabricate, of course, but if it was the arrangement, and a lot of times people make the arrangement in families and then they never talk about it again because they're family, number one, and they understanding is already there that until you get better, you get back to work, you come into money, till you're able to pay me, it's got to be an unconditional loan, Stacy. So it can't be where, well, I would only have to pay her if I got money back. No, it's got to be unconditional, which means, let's say you died, and then, not to be morbid, let's say you passed away, and it turned out that you had an account you didn't even know about, and there's, $30,000 in there. Nobody knew, including you. Maybe it was whatever, and you could as long as that landlord, mom or whoever, could sue your estate for the piece of that money for the debt, for any debt, like a credit card company would too. It's bona fide. It doesn't go away just because you die or because you never get. It's always going to be a legitimate loan. If that's the case, I believe there's something to the fact that they have to take what you say, and unless they can't just go and decide, I don't feel like believing her, but I need to find the POMS. Stacy says, mom and daughter, no way to pay, so going to do a bona fide loan on shelter. Any tips? Are you doing a bona fide loan? Are you making a loan agreement now for now going forward? Which is fine, because if you didn't have one before, you don't want to fabricate you did. You could do it now. Make a lease agreement and say you're responsible for this under your circumstances. I will loan you the shelter until such time as you can start paying and pay back to January of 2026. Something like that, I think. If you're talking about you already had this arrangement, which now it doesn't really sound like that's what you're saying, then you can, if you had a verbal agreement before to the same effect, you can document it now, sign, and sorry, I had to check my candle. And it's retrospective, contrary to anything that suggests it's not accurate. And they can't just fabricate that because they don't trust people. I mean, believe me, I don't trust people. You hear me? But when they have the goods. Yeah, PA, public assistance. I didn't think you meant Pennsylvania, my state. Delia. Hi, Stephanie. Sounds like unjust enrichment to collect 2 insurance claims from the same party. Only when it's public, pseudo-public monies, Delia, I would say. If you yourself had a disability policy here, you bought one privately, your employer provided one, that's not public, that's private, it's not government, partially funded in some way with the help of the taxpayers. I think you can definitely get whatever claims are valid, right? You have one over here from work, and then you bought your own private one because you don't think that one's going to support you, There's nothing wrong with that. And then you could be making 10 times as much as what your salary was. You bought it, they sold it to you, end of story. That's not fraudulent. If they say on the thing, do you have any other disability policies, and you don't tell them that you have the work one, maybe that would be a problem. But I don't even know that they ask that. I mean, I don't know. I don't have one. I know I should. And maybe in a couple of years, I'll feel I can put that into the budget. For now, got to get these kids up and out, and let's get in our new house and all this other stuff. So big spending is not my thing right now. Okay, we've got Lost to Hot. 47, filed for SSDI. Does it make sense to hire attorney now in paperwork stage? I think you're late, actually, if you already filed. Or wait until I get denied 2 times. Some of us won't take you when you're denied 2 times. Some of us will. To me, it depends on if you right when you're denied on recon. So I know I have a lot of time to work up your case. although it might not be a lot of time. It might be a total of 7 months coming and going. And how are you going to follow all my treatment advice? Evidence development advice. So you should get somebody now. At 47, you might have troubles getting somebody. It really depends on your impairments. Spondylosis, I would say most people probably have that. So that itself isn't going to do it for you. Migraines, are you incapacitated? Are you on Botox? Is it 15 days a month? Migraines should pull the day if they're proven and their frequency, but they don't. So I'm just saying from a practical standpoint, I know the way if you are hospitalized all the time with migraines because you get dehydrated and they're intractable, possibly, but otherwise it's something that they try to ignore. And it burns me up because I think when someone's having an actual migraine, not those annoying headaches that feel really bad, they're incapacitated. They're in the dark. They're in the cold room, quiet, possibly vomiting, feeling nauseous, photophobia, phonophobia, and there's no possible way they could do even the most simple third grade sedentary job because they're in bed in the fetal position with something over their eyes. Knees, PFS, IBS, PFS. What is your PFS? IBS is obviously irritable bowel syndrome. I think you probably have a tough case, but that's just based on what you said here, which is next to nothing. So if you can get an attorney now, I would do it definitely because you might have troubles later. I mean, you might have it now, but it's something you want to get on. My opinion, of course, lost to hot. Am I saying that right? It's hard in your 40s. It really is. It really is. And I don't mean to take the wind out of your sails because you could have very, very good evidence and it all comes together and get your art. You have to prove that you cannot do a sedentary job or anything above that. So you have to prove less than sedentary. You almost have to prove, usually it's so clear that you would be not able to work full time. Even if you could work sporadically here and there, the lack of attendance or off task time would be so great. But the trouble is, half the stuff we're talking about happens at home and it's not objectively evidenced in the file with like an MRI, for instance, the migraines. A lot of times we'll point to the person's been treated for 10 years for migraines. If they're on Botox, I always make the argument that, Judge, insurance won't even approve it unless they're very clearly convinced that there's 15 migraine days a month and that it's helping to keep it lower than that. So it's got to be bad enough and that it actually works for them to continue paying. That is what I found. So that can be a kind of soft objective evidence. It's from a company that would prefer not to pay, but they're doing it. So trying to think what else. IBS is hard. I would keep an IBS journal. Actually, migraine and IBS are my two favorite journals. Very, very, very limited what you put in there. Literally use a legend. Don't start talking about the pain. Basically, migraine journal. Some of you have heard this from me before. Only for, well, M is for actual migraine where you're bedridden. And you could have a B, that means bedridden. And nausea, V, vomiting, but bedridden. Not the kind that we sometimes see where someone says to their doctor, I have a migraine today. She drove 45 minutes to the appointment and is having a conversation and sat in the waiting room for 25 minutes. And she's saying she has a migraine. She just pretty much defined her migraines as not very severe. She's able to drive. That's a pretty good concentration skill right there. Migraines put people out and they cancel appointments. Which isn't good, but that's kind of like what happens with an actual, what we think of as a migraine. Now, that's not to say you don't have bad headaches. And I'm not talking about you, lost to hot. I'm just speaking generally now. In a migraine journal, I would put an H on the days that I have a headache that are not a migraine. But the migraines, when you're in bed, those are the M's. And then I would just put the B to make it clear. And then what one can do is every month or so, send a monthly calendar to your doctor or quarterly or whatever it is, with the legend. So you don't want to be doing verbiage. They don't want to read your shit. You know what I mean? They just don't. They don't have time. Ideally, they're going to put that in your file. So when they get medical records requested, here's your little cover letter that says, hey, Doc Jones, here's my, and it might be in the message board. Here's my history of the month of my migraine exacerbations or whatever. I was in bed probably 7 days this month. I just want this so we can track the trends of how the medicine might be working or not working for my migraine over the course of time. And we can, maybe go over my next visit with you. So now you've put it in the record and it's historical. Like a year from now when the judge sees it, it's not like you're just on the stand suddenly claiming you have this degree of whatever. It's actually, you actually gave specifics back then. And so it would be a calendar page with just the little legend things and an explanation of what those mean. B means bedridden. N means nausea. V means vomiting. N, well, you could say And this photo, L, like LS, light sensitive, NS, noise sensitive. Whatever your problems are, and the symptoms that accompany your migraines, that's what I would do it. Super, super simple. Keep it at your bedside because that's where you're going to be. And that's where you're going to be when you get out of your migraine and you can jot this stuff down. IBS, I always say, keep it in the bathroom, a little notebook. Same idea. And for IBS, I think a little check mark every time you had to go to the bathroom. And if it's you could have a check mark number 1, which shows that it wasn't the number 2, or a check mark 2, and then how many minutes you were in there. Like what time did you go? I mean, it's a little more complicated with the IBS. Ideally, you can give the times a day, but that's a pain in the rear. You could just have it morning, AM, check mark 2, 25 M's, 25 minutes. Like you were in there for 25 minutes dealing with this IBS symptom. Number 1 goes by as fast as anybody else. So the only reason of putting the number 1 down is to know that when you add the 2 together, that's a lot of off-task time. That would be arguably intolerable to any employer, particularly when you're just starting with, and you wouldn't get past the probation period. Okay. Keep at it, Lost to Hop, but I would get an attorney as soon as you can. I'm very biased in that way, as you know. Funky Farm says multiple herniated discs with nerve root displacement, right convex curve of lumbar. Will my skills be transferable? I have no idea. It depends on so much more than that, unfortunately. I know easy answers here. There's a lot of details that have to be fleshed through. What is your age, Funky? Did you tell me that already? I don't know if you did. Because that's going to help define between your past work, was it skilled, unskilled, sedentary, and your age? Was your schooling last year or long ago? I pronounced Renee. Renee. Nice to meet you, Renee. Kimberly Rainey. I've tried getting my medical records myself, but was told they cannot email it to me. Either I had to pay, which was a crazy amount. All right, Kimberly, if you want, I'll share with you the high-tech HIPAA form. It's a little obnoxious in one particular area of it, and I did that by design. And you can use a blank form. It spells out that it's high-tech. It spells out that it's your request, that they send the records to you. And it gives, in the footnotes, it gives the law that covers the fact that they have to send these and they can't charge you more than what high-tech HIPAA says, which by definition tends to be less than $10 a pop. You might have to pay this $6, $7, $8, but it beats the dollar a page, right? They can't charge you by the page, and they have to follow this. It's the law. And if they don't follow it, you can report them to the Office of Civil Rights, who has a very easy, quick online form, and or you can fax it. So I always say attached, keep documentation of when you sent it to them, what the response was, on what date, who you spoke to. Give all the details so you can back up your claim. But until people start holding them accountable for their wrongdoing and their violations of HIPAA, I think it's just going to continue to go. Because so many people bend over without the benefit of a handshake and pay it. So to them, it's worth it to try to get the pay. Because probably more than half the people roll over and pay them $75 when they're not entitled to it. It's like how they supplement their practice, or maybe their third car garage. I don't know, but it ticks me off. Kimberly says, oops. I was also told it takes 30 to 60 days. They have to do it within 30 from the time they got your request. And that is probably true with all the HIPAA requests, not just the high tech. But if you want a copy, I think I have the high tech thing on my website under forms, but that might be hard to find. If you want to email me, Kimberly, I will email you back. Somebody will email you back with a copy of the form we use with the little blurbs in there, and you are free to use it. It should be, it might be form fillable. You can just take your stuff in, print it out or whatever. I mean, if I were you, I'd be faxing it to them so you have a proof of the fax receipt. But if you don't use a high-tech HIPAA, they can charge it. And every state has its own, if any, limit on what they can charge you. Some states actually say you can't. Those are nice. But most states, and I know my state, they can charge. So we just use high-tech HIPAA. And yeah, that's me. But yeah, email me, stephaniejoy@joydisability.com, or to Liz, assistant@joydisability.com, and we'll get that right over to you. Okay? It's mostly for fee savings, so you don't have to pay. It doesn't change how fast they have to give it to you. They have to email it or fax it. Both are electronic. So, I mean, unless they don't have their records electronically, and because it only applies to HIPAA, which is the health insurance portability that you work with. But honestly, it's despicable. Despicable. All right. Heather Ash. Hi, Heather. One of my favorite names. Which do you think is worse? Asking to reschedule SSD neurological exam next month due to post-brain surgery radiation treatments, or wait until last minute and not be able to get home. What do you mean not be able to get home? Is it on the same day, I guess, Heather? Let me just, she says something more down here. Heather further says, oncologist is trying to begin treatment within the next 4 to 6 weeks. I need scans and mask made first. Oh, I'll be 2.5 hours from home 5 days a week for 6 weeks. Wow. Yeah. 5 days a week. Does that mean you're staying out there 5 days a week? I would tell them. I think the earlier you tell them, it sounds like they already have you scheduled for something, right? Yeah. And just say, I will be away for up to 6 weeks with my cancer treatment. Am I right with that? So I can't see your neurologist without interrupting my really, really important life-saving treatment. I would imagine they would be willing to. They probably can't move it closer. They probably give you the closest date they have, but just tell them, that's, I've got this going on and this is my life. You don't have to be all dramatic, but it's better than not showing up. All right. Are you driving home all the 5 days every day? No, you're staying there all 5 days, I'm sure, because it's 2.5 hours each way. Yikes. Where do you live that it's so far away? I guess I've always kind of lived in the Northeast, so everything's like technically, I mean, if I had to go to New York City for something, it is probably a couple hours without traffic. Well, without traffic, going just a little bit over the speed limit, probably an hour and a half, but you're always going to have traffic on Route 80, and then, Philadelphia, same idea. I don't like going to cities. I don't know how to drive in them, so I just don't do it. Kim says, Kimberly, 30, 60 days. Yeah. And yes, I'm self-representing, thinking about obtaining a lawyer at this point. Yeah, well, I'm very biased, but I'm always like, why are people being so penny pinching with their future? The money is going to be, in theory, arguably found money if they win it sooner rather than later. And if they don't win, sometimes that's their last bite of the apple. And they're never going to get SSD, and their retirement thereby shrinks. The monthly retirement rate shrinks if you do not win your SSD. For most people, if you do not win your SSD and you do not go back to work, so you're taking a big gamble, particularly when you know how hard it is and you know how tough the laws are. And I don't think I recall what your vocational profile was, including your age, but I'm sure you just said it. Let's see. Nope. Lost to hot was 47. Don't be penny wise, pound foolish is the way I look at it. If these are really small, in terms of the hours put in, so I don't know. I just don't know that it's wise. And me's in the house. Hey, you. She says, hi, Stephanie. Absolutely. In this country, we get retroactive sick care with insurance. Retroactive? What are you talking about? For me personally, all real access to care would be OOP. I'm not really sure. Are you talking about Medicaid? I'm not really sure what you're talking about. OOP, outpatient. Funny what you're talking about, Jen. She goes on to say, care that would actually improve conditions. It is what it is. I have tried everything to access. Even had insurance kick me out of inpatient, as it does to many people against medical advice. Yeah, because I guess it exceeds what the insurance agreed to pay for. I know. Sometimes it's an annual thing though. Like then you can go back to next year. PT, same way. Hang in there, Jen Me. Sunflower. I let my MD know I found the group when they asked about how I'm coping, so it's my record. I think it's fine, Sunflower. It's a support group. And who does that unless they need the support because their impairment is really troublesome? So I think you're fine. I wouldn't find that to be concerning at all. In fact, maybe it's positive. Catalytic converter. I just wanted to pop in and say how much I appreciate you. Oh, that's so sweet, Catalytic. You've made this process a little bit easier and less stressful for me. I really appreciate you taking the time to help folks like me out. It is so my pleasure, and you know that. So I appreciate you sharing that. Today was such a horrible day, and this is really turning out much nicer. That's why Wednesdays are always my favorite. Okay. Is the hearing, this is Patriot in the house, is the hearing the same for appealing onset date as for a hearing for getting approved for disability? Unfortunately, yes. It's considered a medical appeal. Yeah, it's the same kind of appeal. You just appeal it. Like if you prevailed and you don't like the onset date, which I get, it would be the same basic idea. It's not a non-medical appeal, even though you're saying, but it's the date. But it's the medical evidence of that date that points to that date. So it's the medical. Sherry's in the house. Hey, Sherry. When should all your medical records be in before seeing the ALJ judge? As soon as you can get your hands on it, you send it in. The sooner he has it, the sooner he can look at them, or his people, before hearing, potentially. And you could be considered for an OTR if you have really good evidence, and it's not discretionary. You should be sending in evidence all the time. If you're pro se, I think. You just got to be, if you don't have a hearing date yet, let's say you're like, well, I don't want to order the records every day, which I get that. But definitely if you file for ALJ hearing and you have a bunch of evidence that's not already in the file with the SSA, I would send it in as soon as you get. I mean, in theory, they say you can attach it to your online appeal, the documents, if you have them in your computer. So I guess you could do that. We don't do it that way. I do it through the electronic file. Subsequently, once the appeal is in, but that way I could see it and make sure everything's there. Like I just don't know who's going through that submission and all that. So I haven't gotten on board with that yet. Not that there's a problem with it that I've heard of at all. When people used to send their records to the field office, big problem. They never went anywhere. And some people would give their originals and the only copy they had. Not smart. Never, ever, ever do that. Kevin says, how do I send lunch money to you when I get paid? No worries, Kevin. You're so funny. Sherry is number 2. I have a hearing date from the government, the .gov website. How can I tell what judge has been assigned my case? If there's a hearing date, there should be a judge assigned for sure, and they send you a letter. So you'll get a letter in the mail. Did this hearing date did it just pop up and it doesn't tell you online who the judge is? I'm imagining the reason why you care who the judge is, Sherry, is because you want to go research him and see what his rates are, right? I don't think anyone should do that. I know it's hard to resist, but what are you going to do if you find out he's got a 20%? Or what are you going to do if you find out he's an 80%? Slack off? What do you do at 20%? Get depressed and not pursue? Not as robustly? Get down and out? You know what I mean? Like hurt your whole self-esteem there? If you're going to be doing this, the top best job, no matter what, A+ job of representing yourself, I would look to see who's bitching about the judge or what his rates are. I think it's counterproductive. I don't see what good can come of it at all. I'm sure you guys are like, but I can't help myself. I must. I used to look at them when I first started practicing 20 years ago. I used to look them up and I found out there is no point. And what if it affects how I practice? What if it affects how I act on a case? You know, what if this never happened because I didn't let it, but I thought about it a lot. And that's when I said, I don't even want to do that because what if in a weak moment it does affect? What if I found out a judge had a 15% rate? Will I not want to put in as much of my free hours in as I do on every case because I think we're going to lose, or the better chance we're going to lose? Or again, if it's a high winner, what's the chance of her losing? I don't really have to put in that weekend, do I? So I don't think I don't see the benefit, you know. Tasha, you gonna say hi? She's like, nope, she's sleeping. Art of practice. Art. At ALJ hearing, must the ALJ, goodness, my eyes work, consider vocational rehabilitation reports from other vocational experts? Yes, I would say. 1 vocational expert seen during vocational rehab program and 2 independent report indicates unemployable. Yeah, if the records are credible looking and they met you and they worked with you and all that business, yeah, he's got to consider everything. Does he have to believe them over a different one? No. I mean, he might find that you're a different one that's less favorable to you is more consistent with what the medical records appear to say, because remember, medical records are going to be the top dog. But absolutely he has to consider them. So I would definitely get those in if they're just be careful what favorable means and what not favorable for your particular case means. And that can be a little bit of a trick if you're not really familiar. Okay, Mr. Elliott. Or is it? Yeah, I'm just going to call you Mr. Elliott. Yeah, I know you told me how to say it. Polash, or Polak. It's Czechoslovakian. I am a legally blind guy going to law school. Okay, but who was looking for work as an yeah. Oh my God, we talked about that. Okay. Yes, we did talk about that. It could be challenging. Do you use, I'm curious, do you use to read stuff? Do you have it just really big on your screen and you can read it with or without special glasses? Or do you do a lot of listening? Like have it set so it reads it to you? I'm just wondering. Because we could use all the good SSD, EDPNAs we can. Those are the non-attorney reps, guys, for those of you that don't know the acronym. As well as, of course, good lawyers, you know, and usually I would say it's more about the attitude. Everybody's smart enough to do it. Well, most everybody. It's the attitude of what they're willing to do to make it work. Patriot says, I'm hearing for appealing onset date. Okay. Wow. That happened fast. Or no? You had an onset date probably down below. You appealed the onset date. 55. I contacted all my providers. They said SS didn't get any records from them. Is this normal? How would they know? I mean, what they're saying is we didn't send any to SS or we didn't get the request. You get them from your providers and you send them up. If you are self-representing, this is what you got to do. Otherwise, your lawyer presumably has already done it. I don't think you can see what's in the judge's file right now, but you can call them and say, "Can you please give me a copy of the hearing file?" And they should be able to email it to you. And then you can see what records are in there and what records are not. And you need to go get them. You need to go get them. Okay. Yeah. I mean, if any of your providers have a HITMA arrangement with SSA, SSA can and OHO can quickly order them and the updates that subsequent to the last time they got them. But you're not going to know which of your providers have that unless you already knew that. So I know around me, all the major networks, they have HITMAs. It's awesome. Doesn't apply to the mom and pops, and that's fine. But it is nice that they can do that for expedition. Make it, because the medical record, I think, development is the most time-consuming part of the case. Yeah. So it's your job to get them. OHO doesn't necessarily order them, just so you know. They're relying on you to do that, or your lawyer. All right. Monkey Farms. I tried to add 61.5 years old to previous question. I will possibly grid out. Yeah. You're definitely in the age range, 55 and above, for the best possible grid. So it will depend, on all that other stuff. So you should ask. I forget if you said you have a lawyer, but you really need to ask, or an EDPNA. And find out where you're at. Is all the evidence. Umo's in the house. Hi, Umo. Hi, Stephanie. Ms. Joy and her staff are very detailed and very helpful with filing claim. A pain in your butt. What are you talking about? No, I really appreciate their help. We appreciate you. Virginia Gomez is in the house. Hi, Virginia. Nice to see you again. Hey, Chica. It's been a while. May God bless. Yes, please. I can use that. My case went to FDC. That's Federal District Court, everybody. That means she was denied at the Appeals Council, which means she was denied at the ALJ. I have a second SSI going on I don't really know what you mean, a second SSI. I'm 52 in California with an autoimmune inflammatory arthritis, lupus, fibromyalgia since 2017. What my chances? They don't have a chance book. You guys know this. There's no stats book out there. Every case is different. Not only is everyone's reactions and limitations different to all these impairments, but the way your doctor presents it is different. And unfortunately, that's what kind of rules the day. So you definitely don't have the worst case ever. If you said it was just fibromyalgia, I'd be concerned for you. But you put in lupus, and that's probably objectively determined by blood markers and such. The arthritis, inflammatory, there's probably blood markers about that too, right? That's good. Not for you, but for your case. Because the fibromyalgia, I have video on this. In my opinion, they treat it like the redheaded stepchild, even though they have to acknowledge it exists. And they have to acknowledge it's an impairment. And they are going to say it's an MDI and that it's severe when they deny you, not you, but fibromyalgia generally. For some reason, they say all that and they say, but she could still do sedentary or light work because it's never going to take her away from work 2 whole days a month. Doesn't sound realistic to me, but that's what they do. And I think it's because they don't really believe some of the people that are making the decision. Stacy says, thank you so much. I appreciate your information. You are very welcome. Ilya says, I hope I didn't send a bunch of messages. I don't think I know what I was doing. You're fine. No, I don't see a bunch of messages at all. Number 2, I've been getting worse. Oh, Virginia, it says, I've been getting worse. Since then, fighting over 3 years and a half. I'm getting in-home care for me, and they still denied me. I don't know. I'd have to see it. What does your lawyer say? I mean, that's really who should be talking to. Like where are the weaknesses? What do I have to do to help prove my case? And then follow their advice. If they give it to you, we give it, and a lot of times it's not followed. Delia says, how did it go with the vet? I think she's referring to when I had my mobile vet, Dr. Casey. But yeah, he came after our live stream last Wednesday. It went well. It was very expensive, but he took blood work, cleaned the ears, like put in some steroid and stuff to help. The blood work came out all perfect. He goes, I was hoping it was a thyroid so we could treat it and be done with it. But no, it's still with sensitivity. So now we have ordered to see how it goes. High protein. Went with whatever brand. He had a few different brands we could pick from, but I said, what do you want? And he set up the account. Very expensive. It's by Purina. It's hydrolyzed protein. It's none of the regular protein. I guess it's kind of synthetic, but it's to eliminate what could be any of the allergens in the foods. Come to find out, protein is one of the most allergy promoting proteins in dogs. I was shocked. Yeah. And lamb and beef. And that's in all the ones that they say, we go grain free. He doesn't really have a problem with the grain. He has a problem with some of these proteins. So I don't know, guys. I just don't want to see her stinking and itching for the rest of her life to the extent she does. It's just, that's my Bernese Mountain Dog, guys, what we're talking about. We went over this last week. All right. So Elliot says, I just had a friend reach out to me who's 30 years old, but who had a Sudden health issue that's left her legally blind, gosh, with widespread chronic pain, psychiatric diagnosis, and she was denied 12/1/25. Sounds like it's not clear she's legally blind under the SS rules, because that would be a listing. Widespread chronic pain is, of course, very subjective. Psychiatric diagnosis, as you know, very subjective. I have a hearing coming up with regard to legal blindness in a couple of weeks. Young person, and that person's been denied on it's cortical blindness, which means not the same as 2400 plus. You can have better numbers than that, but cortical blindness. And so we're fighting on the legal listing, which is a little more nebulous than if it had been the flat out numbers, unfortunately. But also there's other problems, severe GI problems, such that I want to talk about like malnutrition as a result, inability to keep on weight, and wheelchair bound as a result. So the judge did, I don't know if I'd mentioned it, the judge, I saw some recent paperwork where he is bringing in a medical expert on the case. Those are rare for that. It's always a vocational expert. So there will be a vocational expert too. And then a young person. It's one of my, technically it would be a 1%er, although I don't really think it is a 1%er because I think the impairments are far greater than that. The big argument is actually the physical, not just the blindness. I mean, personally, I think we should put on both. But the fact that the judge brought in a medical expert suggests to me that he thinks it could meet a listing. Now, hopefully the medical expert will agree. Let's see. Funky Farm says, Funky Farm, sorry. Sorry, Funk. Sorry, job info, schooling 16 years ago. That's a long time ago. That's a stone age. Don't worry about that. Vascular tech, ultrasound. That's your job. All right, so you're a high skilled, what's that? OCC, occupational medicine. Doctor notes job exceeds current capacities. Okay. Job is very hands-on and physical. Yeah, how much did you say to lift? 61 years old, will I grade out on skills transferable? I would like to think so. I would like to think so. You can't do medium level work. Can't do your old job because of what reason? I mean, that would be something that has to be persuaded. If you have to lift over 20 pounds for that job, like a limb, like someone's big, heavy thigh, I don't know exactly how you do your job. But, that would go towards proving that you can't do, your job was medium and now you can't do medium. Which brings me, hi, Half Pint. I see your little thing in there. Oh my God, we're coming down on 2 hours already. I see Half Pint in the house. I think it sounds good, Funk. Again, you know where to reach me if you need more one-on-one than that. Heather Ash says, yes, I'm in Western Maryland. Don't even talk to me about Maryland right now. And my treatments are in Baltimore. Oh my gosh, I'm never going to Catonsville, ever. I'm hoping to come home on weekends, but may not physically be able to. Because it's 2.5 hours away. So Western, okay, so I'm just doing the visual here of the mapping. I'm looking at the map. Yeah, Heather, if you have a lawyer, ask him, tell him or her. I just kind of like to be upfront when I know it's going to be, and you could talk to the adjudicator about that. If you don't have a representative and say, I don't know, I mean, first of all, it happens in the middle. You're supposed to be there 5 days a week straight. Are you supposed to cancel a day and come back in the middle of the week? I'm assuming it's during the week, right? So I would talk to them about it, like, listen, this is really important, cancer treatment I have to go for. Can you push that off? Ask them if they can stay it in some way, just because this is so, it's life critical treatment. That's probably what I would do. Northeast-ish. Northeast. Well, you're in the Northeast generally, as am I. I'm just right above you. I'm like 3.5 hours, I think, from the Baltimore area. And I was down there for Thanksgiving. And that's a story for another day. I'll have some tips about what to do if you rent an Airbnb. There are some corruptions out there, seemingly anyway. Okay. Jennifer's in the house. Thank you, Jennifer. Just hope you're doing great. You too, my dear. That colored pink looks really good. Oh, thank you. My little winter long sleeves. What a bunch of them. They were really cheap, which is sad because that might mean it's made in a country I wouldn't want to buy from. And that was a brain fart on my part. But now that I have them, yeah, I'm trying to be really good about not buying things made in China. It's impossible to entirely avoid, but I've found that doing a little bit and saying, I'm just not buying that anymore. I'm going to buy the one that's 25%, 25 cents more that's made in USA or any other country. Well, almost any other country. When I do it in little bits, everything helps for sure. And it's easier to add another one on and another one. So I'm getting there. It's very hard on Amazon because they don't really tell you. Like, I want them to be screaming out, where is this made? And where are the parts made? I really think they should be doing that if they really, yes, some of the people that get things from China are going to have a tough time selling. But there's going to be people that don't care because there are plenty of people that don't give a rat's, right? But then there's some of us that do. I just wish they would do that. I think that would be a very American thing to do, but I'm not holding my breath. Heather Ash says, in the process of finding somewhere to stay downtown Baltimore Monday through Friday. Have you thought of it as I just put it down? But it can be so much nicer than a hotel if you want like your space and your. But maybe not. Maybe just want to go look at the hotel as breakfast. That's kind of nice. Just tough going on 2 years of $380 a month temporary disability. Wow, Maryland gives you $380 a month for that long, huh? That's pretty nice. You don't get that in my state. There's none of that. Yeah, that does sound very hard, my dear. Downtown Baltimore, yeah, because you don't want to have to be driving far, right? Something close to the facility, right, would be ideal. Too bad they don't have like housing there that they can offer you. They're charging you probably out the nose for the treatment, or your insurance company. You can think of that. Jennifer says, since my hearing is over, do I still need to update Jonathan Ginsburg's portal with new medical info, or is it closed now? I don't know how Jonathan does that. We've never talked about that. I would. My bet, once you find out, is that he's going to say, no, don't give me anything more, and you take a break because we think you've prevailed, right? And you wouldn't be doing it. And if for some reason it falls sideways, there's plenty of time to get it up then if you're going to appeal appeals council or refile or whatever you're going to do. So I would just enjoy the break and, don't stop treating, of course. But I don't think you have to worry about that. But you can ask Jonathan for sure. Maybe they have a different way of doing things. Hey, Danny's in the house. Woo-hoo. And so, Jay, yeah, I'm in class late. Yes, you are, but I'm driving. I'm listening. These people can't try to tell me about it. My daughter, for her birthday, we got her a dash cam. And I had my mechanic on Monday. It took a while to get an appointment for this. Install it because I wanted it to be hardwired. She got her a new car last year. She pays for it. And there's been so many issues. We have really bad drivers in the Poconos. A lot of New Yorkers that don't know how to turn the steering wheel, I guess because they're used to straight roads. They don't know how to do curves. They don't know how to stay under the limit. I would say New Jersey's pretty bad too. And I'm from New Jersey, but I lived kind of west. I already knew how to do this stuff. I had a mountain near me. The first video, I guess it's really cool because she can get it off her phone. And it's easy, and I'm so pleased thus far. I've had dash cams before, and they were a real pain in the rear. This was, he installed it. The installation cost more than the camera, but I wanted it done professionally. I trust him. He's never ripped us off. He's a really good guy. And so it's got a rear camera and a front one. And then there's nothing like, you're not plugging it into the old cigarette lighter thing, guys. You can't see where it's plugged in. So it's pretty cool. Like, he did a very good job. In fact, I might have to do it myself. And the first video she sent us, it was yesterday, and it's her calling someone a dipshit. She's making a left to go into the strip mall, and the person is coming out through the in-way. She has to go veer around him. I mean, literally on the wrong side of the divider of the entranceway. So he wasn't on the wrong side of the highway. He was still coming out. But you hear her going, yo, and I'm sitting there going, thank God her windows are closed, because I always say, always curb your temper. There are going to be idiot drivers out there. You do not want to get anyone into road rage, because some people are just unstable and they might do something really stupid and hurt you. So, ram their car into you, for instance, because they are mad and think they can. So just avoid that. But there had been other incidents where dangerous things had happened, and it was kind of scary, including a scary other driver who was aggressive. And so I wanted her to have, and I do think I want to get one in my truck because my son, who's 17, drives my truck more than I do. I think it would be good. It's just a lot of money, but I think I'm going to do it. I think I am. I got to see how I can pass it off for a holiday for him, though. His birthday's not until September. Like hers, we got her for her birthday, but it seems a little unfair. But of course, it is my truck, not. So maybe that's the way I can get around getting it, and it's not for his birthday because his birthday is really far away. All right. Yeah, that gives me good thought. After seeing her video, I kind of like it. All right. Yeah, bad drivers, Danny. OOP is insurance. Speak up. Out of pocket. Like, I'm thinking inpatient, outpatient. I'm thinking medical terms. Okay, out of pocket. No, unfortunately, it isn't a matter of what they agreed to pay for. They just want to take. Well, actually, there are lawyers that represent people if they have been wrongfully denied by it's called a bad faith claim, usually. Bad faith claim handling by the insurance company. So if you think they are actually not complying with the contract, because there is an agreement, and they do have to comply. If it's clear that they are not complying with what they agreed to, because it is a matter of that, then you got to take it up. Because, insurance companies are notorious for leaning, cases that are, let's say the fence is here, definitely the ones on the fence denied, and the ones on the agree side, but within 10%, 20% of it wouldn't be. Like, it's kind of like, let's just shove that over and see what happens. Consider appealing it. I think even in your policy, you can appeal it without a lawyer. It probably goes to arbitration or something. I'm not sure. But also look into that and look into good faith claim attorneys. They would be state level. That wouldn't be a federal thing. That would be state level. It can't hurt to, you have to ask or appeal it on your own. They can cause where you are going to go. Yeah, well, that's true. That's true. Jenny says, I have seen the same thing across insurance companies. There's just no help. There is recourse. You just have to have the energy to do it, right? It isn't right. It is what it is. One reason I will fight for things I fully qualify for, like SFDI. Well, then fight for that. That's a legal contract. So if you say they're breaching their contract, take them to task. You got the energy, Jen, and the brains. Sherry says, you are right. The facts speak for themselves. Thanks for the good advice. I'm not sure what I said, but I'll take your word for it, Sherry. Elliot says, Mr. Elliot says, I use large text and a hand magnifier when necessary, though neither hinders my life. Good. I'll have my driver's license soon, though, by Optic Driving. I'm out for now. I'll email. Talk to you all soon. Oh, see you later, Mr. Elliot. Mr. Czechoslovakian. Yeah. So, by the way, guys, so if Elliot were to become an EDPNA or otherwise work in the disability field, sometimes just as a paralegal or something, legal assistant, and if he gets SSD based on legal blindness, his SGA number is way higher than what the rest of you would be. So he can work part-time, staying under SGA, not, working too much, and still keep both his pay and his disability benefit. If he wants to go full-time, and he can manage it, even with a listing, you're going to lose your SSD. But my goodness, you can work full-time and have a career. His is blindness. They're held to a slightly different standard because they're not having the pain syndrome. They're not having, it's a sensory thing. So one of our major senses. So yeah, either which way he goes for it, I think it's great. And I would love to have, close colleague in the field. Yeah. It'd be pretty cool. GT Dude says, hey, Stephanie, I just won my disability claim for blindness and mental health at the initial application. I'm so happy. I'm so happy for you. Yeah. See, I was hoping someone would announce that they got a good result this week or since last we saw them. Super, super, super. Thanks for all the helpful videos. You are so welcome, and I'm so happy for you. That made my day. Heather Ash says, past Catonsville every time I go to Baltimore for appointments. Don't know anything about it, though. Unfortunately, I do not have an attorney. I'm only 39, and I know my age just makes a huge risk. It is hard. I don't know. Is it like the cancer diagnosis? If it's been clear from your symptoms all these 2 years, I'm assuming it's 2 years, just for the sake of this discussion, and your symptoms have been very bad, your treatment is clearly, now granted, remember there's a 12-month duration. If your symptoms have been bad for 12 months or more, like 2 years, like the kind that you can't hold down the job, the age might not necessarily be such a big factor. Permanency is probably, it could be an award with am I stuttering? Award with not a closed period because you would still be kind of disabled, but with a very close in time DLR. God, I'm saying all wrong. CDR, DLI on the brain, CDR, because Heather, of course, you want to recover and get back in action in life, including, your work. So that might not be the worst case ever, just because you're young. If you had, interestingly enough, if you had a bad pain issues, chronic pain, fibromyalgia, legitimate, totally like, oh my God, literally like can't move, can't even have things touch your skin, all that kind of, you probably have a better case than they do. Because even though they physically can't do a lot of things, and sedentary would even hurt them, and then the depression usually sets in with them and all that anxiety. And if they were your age with that, they'd have a real trouble, but you might not. You might not, given the critical nature of your very objectively proven illness and the symptoms, presumably. The 6 weeks of the schedule interruption, that's not really going to be unless it's been repeatedly, because that's not 12. Like if that was the time that I can't work because of this treatment schedule. Treatment schedules are considered, but that's usually when it's more all around the ear and really, really heavy. And they like to ignore it. Kind of like fibromyalgia, they like to ignore it. But fingers crossed for you. Let us know how it goes. Dimple said, I wish I had a dash cam to have recorded the accident I was in this past Saturday. Yeah, I saw that, Dimple. Oh my gosh. Yeah. I'll tell you, when you buy them and you plug it into your outlet, like I don't want to say the name of the company that I bought more than one from, and it was on the cheap side, and it was more a pain to retrieve the videos that caused me not to do it. So what's the point of having it, right? This one seems to be different. I'm gonna have to have her show me. The last thing I want to do is have to try to get a little tiny disc out of a little tiny dash cam. No, I want it to feed with ease. I think she even said, now I thought she'd have to subscribe to, which might be worthwhile if it's only a couple bucks a month, to a cloud service associated with the company so that the videos are always available online from your computer. Let's say your brother takes your car, which she doesn't let him drive it, but let's say she did. I'm always trying to convince her to let him. He's a good driver. And you know, it's far away, or the boyfriend. She thinks she can tune in there, go to her phone and be like, and watch the road that the person who's driving her car is driving on. And I'm like, that is so cool. I want me some of that. The dash cam itself wasn't that much. I feel like it was like under 150 maybe. That's way more than the ones I bought before. But you get what you pay for. Installation, which probably took at least a few hours, is what cost the most. But I love my mechanic. I love his office manager. I've never been anything but 100% honest, and who could say that? It's a mom and pop. So I don't even ask the price. Just like, yeah, can you do this? Because I knew I wanted her to have it. And I do want my son to have it too, because, you know, he hasn't had the same issues, but they're going to start. All the bad drivers around here. Plus, you know, they're young. They can screw up too. And I want to be able to feed them down when they do, right? Isn't that our job as parents? We bring them down. We could see when they're speeding, so we got him on that one. Dimple says, the guy ran a red light and T-boned me. Oh my gosh, and claimed that he had the right of way, but I had the green light. And the police came, of course. And the police take witness statements. I used to do these kind of car accidents litigation. Sometimes I'll have witnesses that say, yeah, I was sitting here and the green light was facing me, and hopefully that's in your favor or not. Wow. Well, I'm glad you're okay. Although it probably didn't make your body feel any better. When I say okay, I mean relatively, like it wasn't a fatality and you didn't get admitted to the hospital, right? Thank God. But be wary of your body. You went to the ER, that's good. Saying it's like the lawyer that does PI, which I don't do anymore and haven't done in 20 years. You might find in a few weeks that things are hurting, and you know, you might just need to, I don't want to sound litigious, but people drive like maniacs, and people don't even know how to use their blinker anymore. It's like, what do you think it's there for? They don't, I don't know. Terrible drivers, and the only way to maybe hold them accountable and to get them to pay more attention, I hate to say it, if it's their fault, is to make a claim. And I didn't feel that way when I used to do insurance defense. I was very anti-litigious. I'm still anti-litigious. However, sometimes we're kind of not being responsible in this growing age of people who don't know how to drive. They just don't know how to drive. Maybe they give them out too easily. I don't know. But separately, Heather, I don't know. Dimple, I don't know what your state does, but there's something called full tort and limited tort. And in everybody's, I think this is probably most states, guys, everybody's auto policy has one or the other. Your other limited tort that you've opted for, it's an option. It saves you on your premiums. Or you said, no, I want full tort. And your premiums are a little higher. I always go with full tort. Limited tort means you can't sue for certain injuries because you agreed to only sue for some really big, huge ones, like loss of a limb, death. So a few extra bucks a month, my family has full tort. And I only knew that. I only even knew that was like, the only reason I ever knew so much about it was because I did it for a living. Anytime someone had limited tort, we filed a motion for summary judgment saying their injuries don't rise to the level. Unless, of course, they had serious injuries. But, normally it's like the soft tissue injury, like you probably have. Whiplash is another word for it. Anyway, that was just an extra tip, guys. Full tort versus limited tort. Check out what you have, know what you have, and know that. Google it. Nobody Googles anymore, do they? Yeah, it's important to know. Otherwise, you don't have a claim. Okay, we're over the 2-hour mark, guys. Lucky Southern girl. Hope this means approved for sure. Early congratulations by my attorney was awesome. And that's not me, right? No, you're not my girl. But I'm saying congratulations to you. Do I know you? I do have a Southern client, but let's see. Virginia says, number 3, 52, California, SSI case says, it says continuing on step 3 of 5 in the DDS. That means they're Step 3 is the big long one. That's all the medical work up. Getting all the medical records, patient report, all that kind of stuff. Consultative exam, potentially. Can they approve on step 3 with a strong? They can, if they find you meet a listing. That's where you can win at step 3. Otherwise, you can't win at step 3. They will then do an RFC, figure out what your residual functional capacity is after they find that you don't meet a listing, if that's what they find, and then you move on to step 4, step 5, including the grids. Autoimmune disease, titer, the titers, I think it's spelled TITE, hiring all red flags, chronic pain of all labs. I think that's the objective stuff is good. Those blood markers, and if you're consistently always talking and making clear how consistently you have, because chronic pains mean kind of all the time. And long term. Fingers crossed for you, Virginia. Hopefully you'll get it here and not have to go to hearing. It's for life. 45 years, seeing the ALJ at the end of the month. 45 years, seeing the ALJ at the end of the month. 8 years. You've been doing this for 8 years since you were 37. Fourth judge, diagnosed this year with fibromyalgia, cognitive disorder, severe sleep apnea, cervical radiculopathy. To go with previous impairments, you're probably saying, right? Well, good luck with that. I could see that you've had troubles prevailing for a long time, and it's probably your vocational profile, which includes your age. Includes other things, but I think that's the most significant. Let's keep at it. You're probably, if you haven't worked in 8 years, and you didn't exactly say that, but let's just say it is, I assume you're just going for SSI at this point. Unless you earn back those earnings credits, you got to say it, right, guys? By doing some genteel part-time work or self-employment gigger work, so you can gain back your credits and pop back into SSD insured status. It'll take you a few years, most likely. Heather says, was seeking answers to my issues a couple years before losing my job at the U.S. Postal Service. In 2023. 2024, ER found very large meningioma, brain surgery, partial resection. February 2024, for SSDI, 8 of 2024. It's not a cancer case, I think you're saying. At your age, remember, you have to prove that you can't do even a simple sedentary third grade job because of the symptoms, right? So just make sure you focus on why you can't do light sedentary jobs, all right? From a medical, and it's got to be kind of really firmly established on an ongoing basis in your medical records. GT Dude says, y'all, I'm only 32, so don't worry about your age. Just focus on your qualifying listings, medical records, and work credits. Also know there's a long wait for approval. Good point, because I don't think you should not file if you know you can't do any job full time, and you are willing to get the evidence to prove it, which means treat, follow, monitor, diagnostics, make that your main job. Even if it's not full time, it's got to be robust. And I know we don't like to think about it, and people don't, it's stressful, but that's how you have to do this, in my opinion. Generally. Do I always say that? Generally. There's always exceptions. Temple says the 2 witnesses didn't want to stay and give statements. That's because they didn't want to be having to take off of work to go testify in court. Actually, it probably won't go to court. Most cases don't, but it'll probably be settled by the insurance companies. And the insurance companies might want to depose them. That's if someone sues someone else for injury. If they don't, the insurance companies will probably sue each other for the car damages. They'll subrogate. Jen Me says, when you have the most fatal psychiatric disorder, how many things can and should one really have to fight that shouldn't be corrupt in the first place? At this point, it's whatever. I just want my money. Yeah, I don't know. Can't tell you. Don't know your case enough, Jen Me. I know you feel confident in it, though. So, yeah, I know. The insurance companies drive me crazy as well. Hits for Life says, lumbar, chronic, bilateral, radiculopathy, depression, anxiety, asthma. And all depending on the articulation that your doctors do in your records, it's how strong your records are going to be. And therefore, how strong your case is, whether you're over 50 or under 50, Dimples, I'm thinking that I will probably have to get an accident attorney. Probably not a bad idea if you've got some pains, and definitely speak to them without delay to the doctors you do have. Yeah, I mean, if you have musculoskeletal issues aside from that, a big bang like a T-bone can aggravate that. But I would definitely start articulating any new pains. I mean, you should be articulating your old ones anyway, right? You have an SSD case after all. But in terms of any kind of totally different kind of law case, we have liability, any of damages, your pre-existings, of course, will be taken into account and will benefit the other side. But if they're aggravated, and that's what you have to prove, that something is worse than it was, I think communication with your primary care as starters, the orthopedists, are really critical. Heather says the meningioma, it's still growing aggressively, which is why I'm going for radiation. I'm just a mess with headaches, migraines, cognitive problems. You're too young for this. I know it's not fair. Vision issues, dizziness, etc. It's a mess, but I'm still here. Yes, you are. Prayers. Keep up that good fight and definitely keep us posted and see how it goes. Did you say you were denied and you're on recon or are you on initial? I don't know what he said. Funk Farm says, big thank you, Stephanie. You're so clear in your explanations. Some would beg to differ. Funky Farm, but can't please everybody, so thank you. Tony P's in the house. Hey, big thank you, Stephanie. You're so. Oh, that's somebody else. I'm just repeating Funky. Tony P says, that's like Florida. You say New Yorkers can't drive. In Florida, they all think they're on a racetrack. Really? I thought they were all old, but I guess that's the old days when everyone was old that moved to Florida. Then all the young people started moving down, like maybe, I don't know, 30, 40 years ago? What do you think? And nobody uses blinkers. I know. Here they go through red lights, but sit there at green lights. I know. They're texting. And they're texting, Tony, right? They're busy on their phones all the time. It drives me crazy. Heather Ash says, not cancer. Okay, so it's not cancer, but it's this other growth that obviously, if it's in your brain, you've got to stop it, right? And only concrete evidence I have is brain scans. Everything else is obviously subjective. Well, what are those symptoms? Did you tell me above? Oh, the headaches. Well, are you going to a migraine specialist? Are you headaches/migraines? Yeah, I think you were there in the beginning. We were talking about migraines. Cognitive problems. Have you had a neurocog exam? Is it affecting your memory? Vision issues, dizziness. Are you going to a dizziness specialist? It could be a vertigo guy. It could be neurology, probably. You need to, I mean, if you're not doing this, that is what I think will help you. Because like you said, claiming, God, I just made a mess of my hair. Sorry, guys. Looking like crazy. If you don't have it, the vision issues, ophthalmologist, right? And keep going and keep going. Don't let up, because that's the only way they're going to be able to find medical evidence of it, because you keep treating for it. They keep examining you. And that helps bridge some of the pure subjectivity into a little bit more objective. All right. I mean, you have the objective scans. That's an objective. If there's something big in there, and they wouldn't, if that thing wasn't doing anything and wasn't growing, they might not be taking it out or doing the radiation. Right? All right. We got to blow out of here soon, guys. It's 2 hours and 15 minutes and I'm losing my voice. Much Love says, is it okay to work while you're waiting to get approved and you make under 1,600? It can be, Mush, and other times it is not. It depends on what you're doing. It's very specific to your impairments, your symptoms, and the chosen work. And I always say, don't flirt with that 1,600. By and large, people tend to slip over it. Oh, can you take that extra shift? Dimple says, Stephanie, you the best. Thank you for the recommendations. My pleasure, Dimple. Shub is in the house. Hey, Shub. Shub is a big winner time back, and he stops in and visits sometimes. I visits my friend Jonathan, too. He's awesome. Heather Ash says, she's in recon. Appealed last year, but they lost my appeal for about 6 months, and it miraculously appeared when I showed up in the office about 4 months later. Ridiculous. Yeah. GT says, also try communicating your limitations with your doctors and make sure, yes, don't try, you must, with your doctors and make sure your records has those limitations. All sound advice. Heather says, I still see neurosurgeon, neurologist, neuro-ophthalmologist, physical therapy, what is the physical therapy for? Is that for the vertigo or the dizziness? Radiational oncology, PCP, seeing them all in the past month or so. Okay, keep that up. As long as your symptoms are stopping you from a simple, easy job, I would in a competitive work environment, I would keep those up and keep plugging away. Know your DLI, Heather, date less insured. So if possible, you can stay ahead of it at all times. 2034 says, hope your year is to a great start. So far, so good, Tom. Thank you. Does having 4 vascular stents in legs help a case? I bet it does, but there's so many other factors. Mephisto. Oh my gosh, long time no see. If SSA contacts us by mail, do they also contact the attorney on record at the same time? They're supposed to, and you would see it in your letter. It'll say CC to whatever the attorney's name is. However, sometimes people don't get their mail. U.S. mail is not that reliable. And I'm sorry for whoever worked it. I think that was Heather, worked for USPS, right, Heather? Anyway, well, we all know how the mail is. It's not like the old days. So there's a lot of mail I don't get. So I tell my clients, every time you get a letter, message me in the portal letter. Ideally, upload the letter, but that can be a pain, right? Like, what if I'm going to get it in 2 days? So I just say, what is the letter? And if I don't get it in a few days, if you don't hear from me, just upload it. Heather says, PT has been ordered for several things. First, balance coordination. Most recently, it was ordered for vertigo. Okay, if you have I mean, one way to push, if you're very, very unstable on your feet, such that even a sit down job, the 2 hours of having to get up to 2 hours a day, they say with a sit down sedentary job, one has to get up and move around. If that would be provenly unsafe for you, and those physical therapists for the balance and coordination and vertigo, they will hopefully see that you got dizzy with this and this and this. And it might help. I mean, I'm just trying to think of strategies here. It might help to show she can't safely do a sedentary job, even an unskilled one, because if they say your concentration's off, then it's the unskilled, step you'd be limited to. Because the times she does have to get up, she's invariably, or 50% of the time, she has to sit back down again, or she sways in and goes into a piece of furniture. I mean, I don't know what your situation is. Mild vertigo, they seem to ignore that, like you said, because it's subjective and all that, of the severity or the frequency. But if you can get that well documented, where there's objective witnesses, which would be those providers, that might help. Just thinking out loud. And Heather says, so sorry. No, I appreciate it. I'm obviously in bed. Well, good for you. Yes, mail is terrible. I don't work there anymore, so I can say it's a shame. It's not the carrier's fault. I have a lot of carrier clients, believe it or not. Usually older, musculoskeletal problems, all that walking and carrying those heavy bags in and out of the vehicles sometimes. But so it's nothing personal against the workers. It's just they do not do their finances very well. And so I think they're probably understaffed. It's kind of like a hospital that puts too many patients on a nurse's obligation list, who she has to cover that night, and it's just not safe. So the same is true, I think, even though it's not the same safety issue. The performance just can't live up to what they want. So they're just understaffed and maybe overworked. I'm gonna go with that one. Jen says, how many times can federal remand your case? I think indefinitely. When do they just have to make a decision? Well, they do make a decision. Every time you're remanded, there's another decision. So, and then if you don't like it, you'll appeal it again. Mephisto says, I'm late to the party today. Did you get some good advice for your itchy dog? We'll see. I got some answers, but it is going to bankrupt me. I'm telling you. The one thing we did get, I think I told you, it was the hydrolyzed protein food. Yesterday was her first day having it because they deliver it. It's very expensive. I bulked up on my auto ship, so I get a big discount. The max discount I could get, because there is a cap out on the discount for auto ship. And I'll just change my auto ship later, I suppose. It seems to be, they say you could do that at any time. So, because I won't need that much, but I got like 3 bags, I think. Did I get 4? I don't think I only see 3. No, maybe I only got 3. Technically, that should last me 3 months. And by then, we should know if this is helping. But the medicine that we had a couple of years ago didn't do squat. Still the head shaking, the ears get all disgusting. Then I'm reading that I should be putting like hydrogen peroxide to clean them out. And not, you just don't know what to do. I don't know what to do. I mean, it's the same if it has to be forever. She stinks too. Her skin stinks. I think I was saying that last week. Her skin and fur gets gross and grimy within days of a professional grooming at the pet store. Shampoo, defurring, all that. It's just the way it is. And I feel so bad for her. She's a sweet girl, but yikes. Jen says, so if you got a bad judge, you can be stuck in No. You're talking about a bad judge, or how many times can you be remanded and go, two totally different questions. Usually if you remand it back to the same judge, unless he's not kicking anymore. And then if he denies, you appeal again, get denied by appeals counsel, and you go to federal district court again and get remanded again. For a second time, it is my understanding, this has never happened to me, but it is my understanding you can then request a different judge and get it. So you can get away from the judge, but he has to have a second chance. He just doesn't have to have a third chance. I'm just wondering, out of intrigue, my case is in a good jurisdiction now, so I'm not so worried about that. Good. Glad to hear, Jen. Heather says, I still have unsteady gait, but I tend to push it aside. So I know you're trying to do, what you're trying to do might be contrary to your case. So if pushing it aside isn't going to solve your problem, maybe you should not verbally and mentally push it aside. Work towards curing it, but still be very honest about the complaint. You coming over to say hi? Did you already do that? Hi. Do you want to come over here and say hi to everybody? Look, going over. She says, Heather's saying she worked in a warehouse before the postal service. So it's tough going from very active to 2,000 steps on a great day. I bet it is. Sedentary might be a problem you're going to have to try to deal with. They're finding that you could be sedentary. Heather says, I should be receiving a headache questionnaire from the SSA in the mail. Yeah. That's when you should describe it as migraines, if they're migraines. or the differentiation. Say, I got the migraines, head pain, and I got the headaches. And if the migraines put you in bed and make you an invalid, and you can't be doing this, playing on the computer or the phone, and you're just literally like, I would make sure to definitely delineate those. And it's not so much that they're necessarily going to listen to you on recon, but you're setting it up for appeal when the judge sees it. All right, guys. Oops. Benny, you're late. Happy New Year to you too. All right. That's the end, guys. We went a little overtime, almost 2.5 hours. So thank you all for sticking it out. And you know where to reach me. You can always put a question on any, and I'm a little behind in comments right now. It's been a very busy week with that hearing I had yesterday. Hello. You can, so you can see. Always ask a question, even unrelated to a video, just so you don't have to go searching for a video that relates to it. If I can answer it, I will. If it's worthy of a video, ideally, I'll do that and put it on my list. So don't be shy. Occasionally I post things on the main hosting board, and I get a little confused about 2 different boards that they have in here. So anyway, if I don't answer you, I'm not blowing you off. I respond to everything, even if it's just a heart. There's no question or something, or a like. And then when there is something to be said, I try to say it. So I am a little bit behind though, I believe. So I got to get through my portal with my clients first because they must come first. But then I will get to you guys for sure in the next day or so. Anyway, 12 o'clock, daily videos, and every Wednesday at 1 p.m. Eastern Standard Time for our little live fun here. I'll talk to you guys later. Have a good one. I'll talk to you later. Bye-bye.